हाँ
All
great,
right.
good to
So
go.
today we'll start with judiciary. Judiciary. Let me just recall what we have already discussed in judiciary. We have discussed that there are three main levels in the judicial hierarchy, and then there are lower judiciaries. Then there is lower judiciary. There are number of judiciaries that would come under this category, this lower judiciary. There are gram nyayalayas. There are so many other smaller judiciaries, but that is not our concern today. Our concern is for the top level judiciaries. At the top you have the Supreme Court. At the top you have the Supreme Court, and below that you have High Court. Below you have a High Court at the state level. Okay, and then you have the subordinate judiciary, the district judiciary, the gram nyayalayas, etc., etc. We'll discuss them in one go, but our main target is to study these comprehensively. The Supreme Judiciary is one apex institute in the judiciary in India, and high courts actually are so many, and generally one state has one high court, but that's not a compulsion. One state has one high court generally, but that's not a compulsion. Okay, that's not a compulsion. Some states have their own high court, some states share one common high court. In fact, some UTs do not have their own high courts. Okay, they share it with a nearby state. Let's take the example of Lakshadweep, or let's take the example of Andaman and Nicobar. Andaman and Nicobar falls under Kolkata High Court. So some UTs don't have their own high courts because they are too small to have a high court, and some states share their high court. Let's take the example of Haryana and Punjab. They have one high court. Let's take the example of Telangana, Andhra Pradesh. They are two different states but have one high court. Okay, so that's the structure. Then we discussed what the importance of judiciary is, and specifically in a modern democracy. Importance of judiciary, especially in modern democracy. Why do you think judiciary is more important in democracies than monarchical setups?
Because monarchical setups, there's one ruler, so like he has the power to do anything. And while democracies,
And the
they
judiciaries are not independent. In monarchies, generally the judiciaries are not independent, but democracy, by its very meaning, by its very definition, is rule of the people. Okay, it's rule of the people, and when people are ruling, people are, apex in a political setup, it becomes more important to protect their rights, because the very concept of democracy is to give human rights to people. And if you're giving human rights to people, protecting these human rights become even more important, because if there is no remedy to the violation of human rights, there is no meaning of having human rights at the first place. And that's the reason why your fundamental rights are directly protected by the apex court, that is the Supreme Court. The Supreme Court directly protects your human rights. How? I told you. Can you please recall the article number under which your fundamental rights are directly protected by the Supreme Court? You can actually go to the Supreme Court directly if your fundamental rights are violated. Under which article is this mentioned in the Constitution?
ma'am, I don't remember. It's 30 something, if I'm not wrong.
It's 32. Article 32.
Right
Okay,
after all the rights are given.
Yeah, B.R. Ambedkar called it as the soul of the Indian Constitution, because he said you have listed out so many fundamental rights. You have a long list of fundamental rights for the citizens of India, and sometimes even for non-citizens of India. But there is no meaning of giving fundamental rights to people if you don't have a remedy for violation, if you don't have a way out to solve their grievances. In case your fundamental rights are violated, you can directly file petitions before the Supreme Court. Okay, you can file writ petitions in the Supreme Court directly. Otherwise, you can't go directly to the Supreme Court. But in case of fundamental rights, you can directly go. That is the kind of weightage that the Constitution has given to human rights. That's why judiciary becomes very, very important. When you're giving rights, protection of them becomes very important. So judiciary play a very important role in so many different ways, but the two main important roles of judiciary is, first is to give justice to people, and second is to protect the Constitution. Okay, write down a question. Which organ of the government,
Wait, I'll note it.
which organ of the government, which organ of the government is known as the guardian of the Indian Constitution? The guardian of the Indian Constitution. Guardian of the Indian Constitution. Question mark. It is the
The Supreme, the Judiciary.
Supreme Court.
Is it Supreme Court? Okay.
Supreme Court of India. Because it guards the Constitution. How does it guards the Constitution? How does the Supreme Court guards the Constitution? This is the Constitution. It hedges the Constitution, guards it from any unconstitutional policy, from any unconstitutional law that the Parliament may come up with. Okay.
Yes, ma'am.
The political, ultimately, what is government? Government is a party ruling in power. Okay. They may have some political reasons. They may come out, the legislature may come out a law which may not be in alignment with the Constitution. Then the Supreme Court has got the power to struck this law down. That's why we call it to be the guardian of the Indian Constitution. It protects it from any unconstitutional law of the political parties.
Ma'am, I have one question, ma'am.
Yes.
I'm like, if the legislature is making a law, and like, are there any rules to make a certain law which is acceptable by the judiciary? Like, for example, like you said, that
there are different types of bills. You have money bill, you have financial bill, you have ordinary bill. Okay, you have different types of bills, but ultimately the passage of a law in the Parliament depends on the support to that bill, whether MPs are voting in favor of that bill or not. Are you getting my point? There are some specific rules for some things. For example, a money bill cannot come in the Parliament without the prior permission of the President or without the prior recommendation of the President. If the President is recommending something, then you can bring in. And if the President is not recommending by himself, then and if you want to come up with a money bill, then you'll have to take permission from the President to get this money bill even introduced in the Parliament. Okay, but there are no comprehensive rules as to which kind of bill can come. There are general guidelines that you should not come up with a bill and you should never legislate on something which is not in alignment with the Constitution. But if still, let's say the Parliament thinks something to be constitutional, okay, may not have viewed it multidimensionally and think it to be constitutional and has brought in as this bill has been passed because the government might have been having numbers. Now it is the responsibility of the Supreme Court. You may file petition as a citizen. You may file petition as a citizen that this bill is unconstitutional. We want the Supreme Court to look into it. And the Supreme Court can take some matter suo motu. Suo motu means on its own. Let's say no citizen has filed a petition against a particular law, but the Supreme Court thinks that this particular law is unconstitutional. The Supreme Court can directly take that up. Is this clear or not?
Yes, ma'am.
And may appoint some investigation committees or maybe some judicial committees to look into the matter comprehensively, and sometimes there is a need to interpret constitution. For example, see, constitution is not written in a very simple language. It is not written, you cannot understand constitution only by looking at it literally. For example, there is an article number 17, which abolishes untouchability, but you cannot go into this into the interpretation of this article without understanding what the meaning of untouchability in Indian context is. It should not be taken literally. Untouchability doesn't mean you can't touch someone. No, that's not the literal meaning of it. It's a social practice. It's a social evil that Indian society, especially the Hindu society, has been practicing for years, for centuries, in fact, prior to partition. Because ultimately, when we got partitioned and we we started working on this constitution, and when constitution was finally enacted on 26th of January 1950, the moment constitution came into existence, untouchability abolished. It became illegal because constitution abolishes it, and the catch is there is no reasonable restriction to this right. You cannot practice untouchability. No one can practice untouchability against you, and there is no reasonable ground for any restriction. What is reasonable restriction? There are many articles. Let's say right to equality. Okay, you cannot be discriminated on the basis of, let's say, caste, but then there are some exceptions. Okay, discrimination can be there, but that would be positive discrimination. What is that? Giving reservation to those communities which historically had been exploited. Reservation for SCs, or which were historically underprivileged. Reservation for STs, reservation for OBCs, reservation for now economically weaker section. So these are exceptions, but the constitution says these are reasonable grounds, reasonable restrictions, but there is no exception to right against untouchability or prohibition of untouchability. There are reasonable restrictions to your freedom of speech and expression. Article 19 gives you the freedom to express and to speak what you want to speak, but there are reasonable restrictions. For example, you can express what you want to, but your expression should not be harming the common morale of the society. It should not lead to violence. Is this clear or not?
Yes, ma'am.
Yeah. So there are reasonable restrictions to some articles, to some fundamental rights. Some articles are absolute, meaning not carrying any single exception, but ultimately your article 32 is something which you can use to directly go to the Supreme Court in case your fundamental rights are violated. Clear?
Yes, ma'am.
Okay. So, okay, you have written one constitution. Write down one more question here. Which article did Dr. B.R. Ambedkar call to be? Which article did Dr. B.R. Ambedkar call to be the soul of Indian Constitution? The soul of Indian Constitution. The soul of Indian Constitution. The answer to this question is Article 32. Article 32. Okay.
Yes, ma'am.
We also discussed about the appointment of the judges. Okay, and we did discuss about the collegium system. Collegium system. Judges in our country are appointed through a collegium. Is there any doubt in that part? If not, then we'll move ahead. And if you have some doubts, then we'll take that up again.
Collegium, the judges are appointed.
A group of judges.
Okay.
Finally recommending the name of the
Name of the oldest.
judges, and that's how the judges are appointed by the government.
Okay.
No doubt?
No doubt.
Okay. Now let's discuss the jurisdiction and the powers of the Supreme Court. Write down a heading, jurisdiction. You won't have to write everything. Okay, I'll provide you notes, but just write the main headings. Try to make flowcharts. I'll make you make the flowcharts whenever it would be possible for us to make. So first of all, let's discuss about what the jurisdiction of the Supreme Court is. What do you mean by jurisdiction? What is the meaning of jurisdiction?
I don't know. Jurisdiction.
You don't know? Jurisdiction means in what all areas will the Supreme Court have the power to give its judgments? In what all areas? Are you getting my point?
I mean,
In what all areas, and how would the Supreme Court be able to give its judgments? For example, in case of violation of the fundamental rights, the Supreme Court has got a direct jurisdiction. If your fundamental rights are violated, the Supreme Court has got the direct jurisdiction. The Supreme Court can directly look into it. But in some cases, you first of all will go to the lower judiciary, okay? And then only can you appeal before the Supreme Court. You cannot directly go there. So in this case, the judiciary has gotten, the Supreme Court has got a appellate jurisdiction there. It cannot, give judgments directly. Only if you're filing appeals in the Supreme Court can the Supreme Court look into that matter. But there are some areas where the Supreme Court can directly take up the case, right? So when the Supreme Court can directly take up a case, we call this to be the original jurisdiction of the Supreme Court, original jurisdiction. And when the Supreme Court can look into a matter only if you are appealing before the higher judiciaries, you're going up the scale, and you're finally appealing before the Supreme Court, only then can the Supreme Court look into these matters. This jurisdiction of the Supreme Court is known as the appellate jurisdiction.
And so if my right is taken away, that would be, I can directly go to the Supreme Court, right? If
No,
my
it
right
depends on which right. If your fundamental right is being violated, you can directly go to the Supreme Court.
Okay.
But if some legal right is being violated, which is not fundamental, then you may not be able to go directly to the Supreme Court. What is the difference between natural rights, legal rights, fundamental rights, constitutional rights? I'm giving you 4 terms. One is natural rights. Natural rights. Second is legal rights. Third is constitutional rights. And fourth is fundamental rights. Tell me. These are the 4 rights. Tell me what is the difference between them.
I don't know.
No idea?
No.
You can try, you can guess.
Mama, I really don't know.
No idea. See, natural rights are those rights which a human being has got from the nature. What kind of rights do you think have we got from the nature?
Right to breathe.
Right to breathe. Yes, definitely. Right to life is natural right. The nature has given us that. Yes, right to be equal, isn't that natural? It is our
Like,
society,
yes, ma'am.
that discriminates between male and female. The society has created male and female. The nature has given us equally. The nature has sent us to be equals. That is a natural right. Let
Yes, ma'am.
me give you an example. One is born as a male, one is born as a female, one is born as a transgender. The nature was equal to all of three. But what have we done as a society? We have put the male on the highest pedestal, right? The women at a lower pedestal, and we have totally excluded the transgender community or the LGBTQ community. Is this natural?
No, ma'am.
No.
Like,
This is social. By nature, we are all equal. So, right to equality is actually natural. Right to life is natural. All those rights which the nature has given us. Now, right to employment, right to equality in employment, is that natural? No.
no, ma'am.
Somebody is worthy of doing something, somebody is not worthy of doing something. So it is your construct, right? It's not natural. What are legal rights? Any right which is given to you by law is a legal right. For example, right to property. Yes.
Yes.
For example, right to inherit from your parents. You inherit property from your parents. Is that legal right or not?
Yes, ma'am.
It is legal right. What are constitutional rights? All those rights which are mentioned in the Constitution. For example, right to property is mentioned in Article 300A of the Indian Constitution. Right to property. These are constitutional rights. All those rights which are mentioned in the Constitution are constitutional rights. Now, all constitutional rights are legal rights. Anything which is in Constitution is legal. But every legal right may not be constitutional. There may be some rights which are written in laws other than the Constitution, which may not be a part of the Constitution. Okay, for example, let me take the example of right to contest elections. Now, the Constitution is not talking about this thing. It is the Representation of People's Act. I don't remember whether it's 1950 or 51. There are two acts actually, right to Representation Act. Yeah. No. Sorry, pardon. It's Representation of People's Act, 1950, and there is one 1951. I don't remember exactly where it is written, but it's there. You can contest what are the qualifications that you need to have are given there. Okay, so it is a legal right, but is it a constitutional right? No. Then let's talk about the fundamental rights. The fundamental rights are those rights which are mentioned under Part 3 of the Indian Constitution. Fundamental rights are those rights which are mentioned in Part 3 of the Indian Constitution. Chapter 3, Article 13 to 35. Some articles give you just the definitions of what let's say state is, but overall this chapter covers Article 13 to 35. So anything mentioned in this chapter is a fundamental right. Now all those fundamental rights are constitutional because chapter 3 is within the Constitution. Let me just collect all of this and clear it to you. Fundamental rights are written in the Constitution. This is fundamental right. This is the Constitution. This is the collection of laws, including Constitution. So anything that is fundamental is definitely within Constitution and is definitely within the law books. Okay, and anything which is constitutional may not be fundamental, but anything which is constitutional is definitely legal because it is within the collection of these laws. Is this clear now?
Yes, ma'am.
Okay. Now, answer some questions. Is it necessary that a constitutional right is a fundamental right too?
No, ma'am.
No?
Like there are not all the constitutional rights are fundamental.
Hmm.
And because like fundamental rights is a sub part of the constitutional rights, and constitutional rights is the sub part of the legal rights. So like there are few rights, constitutional rights, which are not a part of fundamental rights.
Yes.
And but
Yes.
like I don't know like the proper
No,
one.
no, yeah, great. All those rights which are fundamental are constitutional, but there can be some constitutional rights which may not be fundamental rights. Basically, if this is fundamental right, these are constitutional rights, these are legal rights. So anything that is fundamental is both constitutional and legal. But there can be some fundamental rights which may not, sorry, there can be some constitutional rights which may not be fundamental. There can be some legal rights which may not be constitutional. Clear?
Yes, ma'am.
This is how it is. Okay, now let's come to your book and let's see topic by topic. This was the crux, overall crux of this chapter. Now let's see. First of all, we'll get into functions of judiciary. Functions of judiciary. Importance and role of judiciary in every society can be judged by discussing the following function. Let's look into the functions. The first function is administration of justice. The judiciary administers the justice. The judiciary administers the justice. Clear? What is administrating something? What is the meaning of administrating something?
Administrating mean administrating. I can't get the perfect word for it.
It's okay, it's okay. Just explain.
Administrating means looking after. Administer means keeping track of something.
Yes, yes, exactly. Managing something. Okay, so justice is administered by what? Judiciary. Judiciary administers, manages, keeps track on giving justice to people, focuses, manages justice in the country. So the first function of judiciary is to administer justice. The second function is interpretation and application of laws. Judiciary interprets the laws. Are laws that difficult that even the judges and the advocates need to interpret it? As I've told you, there are some rights. In fact, the entire constitution is at times interpreted. You cannot take it literally. As we have just discussed in case of untouchability, you cannot take it literally. Because the meaning is something else and the dictionary meaning is something else. The message that we want to convey through our constitution is something else.
So like untouchability is there, right? Like it's a rule. Untouchability meaning, is untouchability there or it's not there?
It's actually legally it's abolished. Constitutionally it's abolished now.
Okay, ma'am.
But it's still being practiced in India today in very subtle ways.
Yes, ma'am. Okay.
Okay, can you give me some examples?
Examples, ma'am. The beggars in the street. Like people still don't hang around.
Have
with
you
them.
ever seen untouchability being practiced?
Untouchability, not like practice, not like if someone's shadow is falling on me and I'm going and having bath, but like we are trying to avoid them a bit, I would say. And like, yes, ma'am. Like as you said, in subtle ways they are being practiced.
Dobsang, is there any backward noise? Is there any background noise? No,
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 ma'am.
not at your not at your side, from my side, because some construction work is going on in the adjacent building, and I think voice is coming, but
Yes,
I don't know
ma'am.
whether.
Ma'am, but it's not interrupting the class, ma'am. It's fine.
Okay,
It's
all
little bit
right,
is there, very little. Yes, ma'am.
okay, okay, all right. So yeah, so the judiciary interprets the laws. The judiciary applies the laws. Judiciary actually uh, you know looks into the constitution. For example, let's say some constitutional article is left unused till date, has not been used till date. There are possibilities, right, that a particular provision has not been used till date, but suddenly something happens that you there falls a need to use that article now, but you don't know what exactly the meaning of this article can be, because some people are reading it in some other way, some people have a different perception of it. Now whose decision would be the final decision? It will be the judiciary's decision that would be the final one. The judiciary would be the final authority, right? The judiciary's decision would be the final decision. What the meaning of a particular article is would be uh, decided by the judiciary. How? The judiciary appoints constitutional benches for it. Okay, the judiciary appoints the Supreme Court. The Supreme Court appoints constitutional bench. Okay, and there should not be less than 5 members in this, 5 judges in this constitutional setup, constitutional bench, whose duty would be to interpret and give their judgment on a particular article. And how would they interpret? Their human beings ultimately. They would also read the constitution in a way that others must have read. It's no different English, and there are no, different scholars. Then how would they interpret the constitution? How can we, trust on them, rely on them to interpret the constitution?
Ma'am, I didn't get your question.
Look at the preamble. Okay,
Yes, ma'am.
look at the constitutional discussions which are on record in Parliament Library. The discussions which took place while we were making the constitution. Through these records, Parliament archives, and through the preamble and through overall philosophy of the constitution, do we interpret what the meaning of a particular article can be, what our constitution makers would have been trying to say. We can interpret that article by understanding the overall ideals of the constitution. Okay, which uh, you know uh, can be understood by interpreting the preamble, by looking at the values stated in the preamble. For example, equality is mentioned in the preamble, at the same time social justice too is mentioned in the preamble. So if then there's an article, let's say right to equality, but this article, let's say, just assume, was left untouched till date, but now you need to use it, interpret it, because people are talking about it, let's say, trying to justify something on the basis of this article. Now the need of the hour is to interpret this article, what the meaning of this article is, about which there is a lot of hue and cry. The constitution will then, the judiciary will then appoint a constitutional bench. The job of this constitutional bench would be to interpret this particular article. And how would they interpret? First of all, they must have, and since they are all lawyers, so they know what the constitution's philosophy is. Still they can refer to the parliamentary debates, to the constitutional assembly debates, and they can also look into various other parliament debates, Supreme Court past judgments. They can refer to the preamble, and then they can interpret a particular article, and then they may justify that reservation on the basis of caste is reasonable. Reservation on the basis of caste is reasonable, because yes, our preamble is talking about equality, but at the same time our constitution makers had written social justice there, right? So we have to balance both equality and social justice. And people who had been underprivileged, not because of their own incapacities, but because of the social structures that we had. Since people had been underprivileged in the past, now we are giving them some kind of additional benefit, positive discrimination. That's not inequality. That's in alignment with the Constitution preamble. Social justice. Had social justice not been mentioned in the preamble, had abolition of untouchability not been there in Article 17, we might have been confused. Why do we offer reservations if we are talking about equality? Isn't it? But since we have such provisions, we can justify these kind of positive discriminations. Is this clear, Lobsang?
Yes, ma'am.
Okay. The Constitution also play some role in the Constitution plays some role in the lawmaking. How? Sorry, pardon, not the Constitution, the Judiciary plays some role in so lawmaking. Lawmaking. How?
The lawmaking. And because once the
Can
law is made to make
can the
that come in,
judiciary can the judiciary make laws?
like not exactly, ma'am, but the laws which the legislative make, they can pass it, like they can make that law come into power or not. So like they have the upper hand of allowing that law to come or not. So like they do discuss, I think the judiciary, they do discuss if the law should come in power or not. So like they do have a little role in lawmaking. So that's
No, not that way. They actually make law, but not in the conventional way. Not like the parliament, but they do make law. And how do they make law? Actually, they make some kind of rules for some things. I'll give you an example. Today we have laws against sexual harassment at workplace. Okay, we didn't have these laws earlier. The year was, I guess, 1991 or 1992. There was no law which would protect women against these kind of crimes. There was a woman, Bhavari Devi, who was gang raped in Rajasthan when she was on work. Actually, she was an Asha worker, Anganwadi worker. You know what Asha workers are? In the rural areas, you had small preschool kind of setups where the students would get, where the children would get their initial education, and their health, nutritional intake would also be taken care of. How the government supplies them food grains and other food intakes, so that minimum calorie intake, minimum, micronutrients are given to the children, so that they are not malnutritioned. After all, they are the future of this country. So you have these Anganwadi setups in the rural areas. Now the workers in these Anganwadi setups, they don't just have the duty of giving basic education to the children and preparing food and serving to the children. They also have got the opportunity to spread social awareness in their surroundings, social awareness regarding so many issues. For example, you have child marriages. For example, you have, let's say, female feticide. So their job is also to spread social awareness in their locality against all these things. That these all things are social evils, nothing else. Okay, and this should be stopped. Now there was a child marriage in Rajasthan that was taking place. There was child marriage, and she had raised her voice. Now it's not uncommon in Rajasthan. Rajasthan has had a culture of child marriages. especially some of the northern states, are very anti-women, I would say. Obviously, not every one individual is anti-women, but in general, they are anti-women. For example, the largest number of female feticide cases come from the northern states. Okay, the largest number of honor killings come from the northern states. The largest number of child marriages come from the northern states. So Rajasthan is one amongst those. So she raised her voice and she, I think, filed some complaints or something. She called up the police. Okay. And she belonged to the so-called untouchable caste, the SC caste. Okay. And the marriage was going on in a so-called upper class family, upper caste family, sorry. And since it was all their plan was spoiled, she was gang raped by the upper caste men in her village, in the same family where she had uh, complained about. Now she went to the Supreme Court, she went to this NGO, that NGO, she didn't get enough justice. But then there were so many NGOs which were fighting for her, so many NGOs which were working for women empowerment and fighting for her, and they uh, filed a case. They filed different cases. Everyone would file a case in the Supreme Court, and Supreme Court gave out some rules, some guidelines in this case. Okay, Supreme Court gave out some guidelines in this case. Now, what are these guidelines? They are known as Vishakha Guidelines. Vishakha was an NGO actually. Okay. So this case became Vishakha case, though it was just the name of one NGO and so many NGOs were fighting for her. So all those petitions were clubbed under one title, that was the Vishakha case, and Vishakha guidelines were brought in by the Supreme Court. And on these same lines, the parliament would later on, after almost 10 years, the parliament would make laws against sexual harassment at workplace on the basis of these guidelines. But earlier, these rules were given by whom? The judiciary itself, the Supreme Court. This is how the Supreme Court at times plays the role of lawmaking as well. Clear? Then equity legislation. Equity legislation. Where a law is silent or ambiguous or appears to be inconsistent with some law, some other law of the land, the judges, depending upon the sense of justice, fairness, impartiality, honesty, and wisdom, decide the cases before them. Such decisions always involve lawmaking. It is usually termed as equity legislation. Dekhiye, what is the Supreme Court doing, or what is the judiciary in general doing? When a law is silent on something, is not mentioning a particular, is not addressing a particular issue in a bigger issue, okay, the judiciary may come out with additional provision in to that law, and it would be applicable. If the Supreme Court is coming out with this judgment, then it would be applicable throughout the Indian jurisdiction, throughout the Indian territory. And if it is being given by some high court, then it would mainly apply to the area which would come under the judgment of the that high court. But everybody should get inspiration from it. That's the overall logic behind the judgments of the judiciary. Is this clear or not? Basically, the high court's jurisdiction is in that particular state or the area which comes under its jurisdiction, but the jurisdiction of Supreme Court is throughout the Indian territory. Is this clear? Yeah. Now, protection of rights. The Supreme Court protects your right. Do I even need to get into it? First is No, but still see, first is Article 32, which we have already discussed about, that you can directly file writ petitions before the Supreme Court in case your fundamental rights are violated. Second is your which article is it? I guess it's 228. 228, under which you can go to the High Court. 228 or 226. I'll confirm it. Okay, I'll confirm it and I'll let you know after the class. Just a second, let me just see. Yes, it's Article 226. Under Article 226, you can go to the High Court in case your fundamental rights are violated. Now it's your choice. You want to go to the Supreme Court, you can go under Article 32. If you want to go to the High Court, you can go to the High Court under Article 226. Okay.
Yes, ma'am.
Second is okay, that's it in this page. Now, guardian of the Indian Constitution. We know Constitution is the guardian of the Indian Constitution. Sorry, so judiciary is the guardian of the Indian Constitution. Yes. Okay. Next is to get enforced in decisions and judgments. To get enforced its decisions and judgments. Let's say Supreme Court or the High Court is giving some kind of judgment. Will it be enforceable? If the judiciary has said something in a particular case, will it be enforceable in further cases? In general, yes. Yes. For example, let's say the Supreme Court in 2015 in Putta Swami case said Article 21, that is right to life, has one right inherent in it, and that is the right to privacy. Right to privacy is a fundamental right within Article 21, that is right to life. So will it have applicability? Will it be valid in general? Yes.
Yes,
The
ma'am.
Supreme Court has said it is, it is.
Right to privacy meaning like if someone barges into my house without any proper permission or anything, would
Yes.
that be a part of right to privacy?
No, I'll tell you what right to privacy is. For example, nobody can take your data without your permission, any kind of data.
Oh, like my
Nobody can take your
date of birth
permission,
and
nobody can get your information without your permission. Nobody can enter into your personal space without your permission. All that comes under right to privacy. Okay, let's say this Aadhaar card issue was there. People were saying that Aadhaar card is being asked almost everywhere, and Aadhaar card carries so sensitive information. It has our fingerprints, it has our iris scan, etc., etc. So judiciary in 2018 gave a judgment that now onwards you won't be asked about you won't be asked for Aadhaar card in it would be important in some areas. For example, if you are opening a bank account, it would be necessary, but not everywhere. Let's say if you are to get admission in a particular school, they would demand your Aadhaar card, they would ask for your Aadhaar card. Now you can deny it. Aadhaar card is mandatory only in some areas now. Otherwise, if you don't want, nobody can force you to get your Aadhaar card details, because that's again right to privacy. Right? If you're so sensitive information, see, your fingerprints are there in DigiLocker with the government. What if your Aadhaar card details are leaked and somebody uses those fingerprints and all in some criminal case? This is so sensitive in information. What if somebody uses your, what if someone uses your, this iris scan to do some big fraud or some big terrorist attack? Anything. It's so sensitive in information. right? So that's why the Supreme Court said now onwards it would be mandatory in some areas, only in some areas. Let's say if you want to get some kind of if you want to get some kind of benefit from the government, you want to get the benefits of some particular scheme, then you'll have to give it. You have no other option but to give it. Because how would the government know that you are a valid person, you're a real person, if the government doesn't have your Aadhaar card identity? Okay, so in some areas it is useful, but again, in some areas it is not. Okay, that's all. Now we'll move ahead because I have a class. We'll move ahead in the next class to special role of judiciary in a federation. We'll start from here. Okay,
Okay, ma'am.
and yeah, just a second.